Wow. Participants are arriving. I'm watching the population grow.
Just don't tell me how many so I won't get freaked out.
No need to be freaked out. Workers' comp is a wonderful, comfortable place in life.
Really?
Yes.
Since when?
Yes.
For whom?
Well, the old joke was, remember Mike used to say, the weekends are kind of bittersweet because I get to see my family, but I have to stop doing workers' comp. So
Aww.
kind of a top up. And I would say, well, you can always do workers' comp in your head. That's what's important. Okay. If you're listening, folks, we're just waiting for the participants to fully populate, and then we'll commence. All right, well, let's just go ahead. Hello, everybody out there in workers' comp land, and welcome to another webinar by Sullivan on Comp. I'm Mike Sullivan, and I'm here with Megan Sullivan. We'll see. I guess I should just do introductions with our titles and everything. So I'm the general managing partner of Michael Sullivan and Associates. I'm also the lead author of Sullivan on Comp, which if you're listening to this, you probably know what it is. It's a big, long treatise on workers' comp law. And one of the things we do is we do a lot of webinars, dozens of them since COVID began, and over through the years, we must have done at least 100. But when something special happens in the industry, like we did with COVID, sometimes we open it up, not just to Sullivan on Comp subscribers, but to the whole world, which is what we've done here, because we think it's important enough, the issue we're talking about today, in order that we want everyone to see it. So that's we open it up. Now we also have with us Megan Sullivan, who's a managing partner, senior partner over our Northern California offices. Hello, Megan.
Hi, Mike.
All right, and we have Angela Stanford from Kaiser. Hi, Angela. What's your actual job title over there?
Risk specialist, workers' compensation risk specialist.
Okay, so what do you?
A lot of S's, and I have a list, so that doesn't help.
What do you actually do all day?
Nothing.
See, I told you workers' comp was a peaceful, wonderful place.
It's true.
Yeah. All right. So what we're here today to talk about is the new QME regs. And it's important because the new QME regs apply, well, in a lot of situations as of now. And there's a lot of challenges presented by them, some new workflows and things we need to attend to, declarations and sending records. If we don't do it right, we could really screw it up. So we've been thrashing around with this thing for a couple of weeks now, right? The three of us?
Yep.
Yeah. Trying to figure out all the issues, trying to figure out the right thing to advise our clients, et cetera, et cetera. So what we're going to do is we're going to present them. I'm going to tell you what's in the regs, and then we're going to tell you the issues we're seeing and the suggested workflows. All right. Are you ready?
Ready.
Everybody feel ready?
Well, do you want to point out that these haven't gotten the rubber stamp from the Office of Administrative Law yet, but the DWC and AD have approved them?
Yeah, we're getting a little bit of in and out on your voice there, Megan. So I want to check that out. Yeah, we decided that I was just going to take the lead here at the beginning and run through what these regs are. Now they've been in place for a long time. I'm sorry, they've been an issue for a long time. So what happened was there was this audit of the of this issue, outside audit, and they went to the administrative director and they said, "Hey, this isn't working so well." It was pointed out that the fees for QMEs and AMEs, which are part of QMEs, were last changed in June 2006, and the regulations were last amended in 2013. And there was perceived to be abuse, or at least an increase in the amount of time that QMEs were spending on the cases. So up until now, okay, Megan, you're moving around. Okay.
Sorry, I'm trying to correct the voice problem. Is it
Okay,
better?
I think you've corrected it. Yeah, you're good. All right. So, it turned out that the average QME earned 240% more from panel reports than in 2007. So, they have to, up until April 1st, they would just certify how many hours they spent, and there wasn't a lot of control on that, right? Most of the time was spent reviewing records. So the idea here was to give a flat rate for various types of QMEs, and then add some time for review of records in sub rosa. And that's what they wanted to do. And the idea was to reduce costs but give more stability so we can attract more QMEs because we don't have enough QMEs, right? And also to give predictability as to how much these things would cost. So that now they came up, there's all these committees and all this stuff, and they finally come up with this whole new system of regs, and they redefined how to pay QMEs altogether. So there's this flat rate schedule, and then it's going to be $3 per page reviewed by a QME over 200. So the first 200 are part of the flat rate. And after that, then you got to pay $3 a page for the QME to review records. And here's how it works. So missed appointments are going to be $503.75. And that's when the injured worker doesn't show up, the interpreter doesn't show up, or the injured worker is more than 30 minutes late, or if the appointment has been canceled within 6 business days of the scheduled appointment date. So no show, $503.75. So if sometimes that'll happen, and then the QME will produce a report reviewing records. And in that case, they're entitled to $3 per page that they have to review in excess of 200 pages. If this is the subject of abuse by an applicant, then the employer, it says, may seek credit against the applicant, which would be filing a petition with the board and trying to get that money off the applicant's award by showing that they're the ones that blew the appointment. So that's missed appointments, $503.75. A basic, they call it a comprehensive medical legal evaluation. It's always called different things, med legal, QME, AME. I remember they used to call it a formal medical evaluation. I think it's in the reg somewhere. I said, what is that? And they said, well, it's a medical evaluation in a suit and a tie.
Wow.
But anyway, it's called the comprehensive medical legal evaluation here, and it's $2,015. So that covers the exam and 200 pages of review. And then you have follow-up medical legal evaluations. That's like after they've seen the applicant already once. And that's $1,316.25. It's defined as a medical legal evaluation by a physician that occurs within 18 months of the date of the original examination. So as long as it's within 18 months, that's $1,316.25, not $2,000, $2,015. And then the third type is a supplemental medical legal evaluation. And that's when they're not actually physically seeing the patient, but they're asked to issue a supplemental report on an issue, right? So that's $1,316.25. And all these include 200 pages of records, right? And $3 after that. Actually, though, the supplemental med legal evaluation only includes 50 pages of records, not 200. So that's the only exception. That the base fee includes 50 pages of records, not 200. Okay. So then they have this language. You remember, I mean, time and time again, I kind of felt suspicious of some of the QMEs. I won't say all, but they leave things off, right? They didn't address all the issues. Most commonly I saw was they wouldn't give you a permanent and stationary date. So you don't know when the TD stops. So then you write them and say, give me the answer to the question I already asked, right? And then they give it to you and then they charge you $1,500. Mm-hmm. So they recognize that kind of thing. And they said, look, if they're addressing an issue that was already requested by a party in a prior exam, then you don't have to pay anything for the supplemental exam. I'm imagining that there could be some situations where, you're asking for a supplemental exam on a bunch of points and only some of them should have been addressed previously. I'm not sure what's going to happen there, but I'm pretty sure you're going to probably end up paying them because there's no apportionment in workers' comp. Although principle's never been applied to med legal examinations. Yeah. So I guess that's an area where there may be disputed. There's also no fees allowed if the physician reviews information that was available before in a prior exam. So both of those things are carved out. No abusing the supplemental medical legal evaluations. So that's, I guess, good. It also says that if they don't issue a supplemental report because of an inability to bill for the report for some reason, then they're subject to discipline by the administrative director. Okay. Now, when might they not be able to bill? Well, we'll see in a second that there's going to be declarations required. Everyone's got to sign a declaration about how many pages are being reviewed, right? And if you don't send the declaration, then they're not supposed to review the records, and it doesn't count for the report, which means you're gonna have to do it all over again. Hopefully they'll call us and say, give us a declaration. But anyway, so there's more fees. There's $455 per hour for depositions, for medical legal testimony. I guess that would include testimony in court, which never happens in workers' comp, absent a specific petition on a specific case, and I've never seen it. So it's $455 an hour by quarter hours or a portion thereof. They're to be paid a minimum of 2 hours for deposition. And if the deposition is canceled 8 days, more than 8 days before the exam, less than 8 days before the exam, then they get 1 hour for the deposition. One thing I'm kind of wondering about is when we set doctors' exams, they demand that you pay them up front.
Yeah.
It's probably good practice just to pay them up front an hour because the applicant won't show up. And it's just easier to get it paid when you do it.
You're talking about depositions though, right?
Huh?
You were talking about depositions?
Yeah.
So the applicant almost never shows up to a deposition.
Oh, yeah. Sorry about that. I meant the
That's
defense.
okay. I just thought you guys wires crossed a little bit there, maybe.
Yeah, that's okay. I'm having a senior moment. I'm sure it'll happen less and less through the years as I get older.
Then they'll just be moments.
Yeah. It'll pretty much be Megan correcting me all the time. It's going to be in my future.
Yeah.
It's so different from now.
And then finally, there's sub rosa. Now they realize you can't bill by the page for sub rosa. So they said it's $325 per hour, measured again by quarter hours or portion thereof. And then they have to sign a verification and a penalty of perjury of the time spent that they review the sub rosa. If they're received before an exam, they have to review it before the exam. They can't create a supplemental report of the sub rosa if it's received before the exam. So, I mean, I think there was like a committee, like weren't Kaiser part of that committee that helped create these regs?
Yeah, we actually made a lot of good recommendations. And one of the big things that got in the regulation that we thought was very important was that supplemental issue, that if they had to do a supplemental because they did not answer a question that was initially asked, that we shouldn't have to pay for it. And we're happy that got in there. But we fought tooth and nail about this per page thing, and it looks like they didn't care. Yeah, and we knew they wouldn't, because the doctors on the committee were not going for it. There was going to be a per page no matter what. And we were like, okay, $1.
So you're saying this is your fault? You're saying this is your fault? Is that what you're saying?
Just for clarity, for some of the questions being asked, and also before we move on, when we talk about pages, we're not talking about pages in the doctor's report. We're talking about pages that the doctor reviews. And every piece of paper the doctor reviews that you send to him or her is going to be $3 a page. Mm-hmm. And that includes deposition transcripts. When you send those condensed, you're going to get a bill for 4 pages if it's condensed. You can't condense it down.
Can't sneak out of it. Every page you says is records. But I'm going to get to that. I'll give you some more. Let me give you some more, and then we'll get to the issues. If there's an interpreter, you increase the base rate by 10%. If it's an AME, then you increase the base rate by 35%. If it's an interpreter and an AME, it's 45%. See, now, so they don't stack on top of each other. You don't multiply it by 10% and then multiply that number by 35%. They're add-ons to the underlying fee.
And that's paid to the doctor, correct? On top of the base rate.
Yeah. That's what the doctors get. If it's a psychologist or a psychiatrist, it's doubled. It's increased by 100%. And then, of course, if there's an interpreter, it's 110%. And then if it's an AME, it's 135%. And if it's an interpreter and an AME, it's 145%. Wow. So not too hard to get the $3,500 if you're a shrink, right? See, that'd be 145% of 2,000, 5,000, something like that. Anyway, then there's also bump ups for toxicologists and oncologists. Now, that's not all internal doctors, not all internal doctors. Toxicologists study the effects of chemicals on your health, right? So if you have a chemical exposure case, that's a toxicologist. Oncologists deal with cancer. So in those two cases, you're going to have a markup. And all other internal reports for other internal conditions that don't have to do with chemical exposure or cancer, then you don't have the markup. But when you do have the markup, it's increased by 50%, 60% if there's an interpreter, 85% if there's an AME, and 95% if there's both. But that's all the markups that there are. And then the next thing they say is everybody has to do a declaration. The doctors have to do a declaration under oath saying how many pages that they reviewed. And then the parties, and folks, this is gonna, Megan, you pointed out before we started that I should have started with this, I think. The parties, when they send records to a doctor, they have to do a declaration about how many pages are there. We actually have created a declaration within the firm. It says, check this out. It says a physician may not bill for review of documents that are not provided with this declaration. So no declaration, no review, right? Okay.
Yeah.
And then it also says that without the required declaration and attestation, it must not be considered available to the physician or received by the physician for purposes of any regulatory or statutory duty. So that means if this is what's going to happen, people aren't going to send a declaration, and then the QME is going to say, where's the declaration? Then we're going to have ex parte communication. I can't remember, Megan, would that count as communication or information? Would that blow the report?
The declaration?
No, the QME calls and says, give me a declaration from one of the parties.
Well, it depends on if the court interprets that as purely administrative and if it goes to the secretary or not, right? If you're having substantive communication, then you could be alleged to have had ex parte communication.
Right. So anyway, that's the bill. I mean, that's everything that's in it. And of course, the big issue is the $3. But before we get there, we have to talk about, when does this apply? It's not official yet. It won't be until it's approved by the Office of Administrative Law on April 1st, but it's effective April 1st, right? So let's see, actually it's effective April 1st for all exams after April 1st. And it's effective for all supplemental reports requested after April 1st. So if you have supplemental reports out there in the world and you haven't submitted a declaration and you haven't counted your pages, then you're fine. But after April 1st, you won't. But the problem is you got all these reports that are scheduled for after April 1st right now.
Yeah.
And in many instances, we've already sent records and there's no declaration, but all those things are required. It's retroactive. So what are we going to do?
Right. Hey, you mentioned that it wasn't finally approved yet. Is that a governor's signature, or is it just up the regulation chain?
Yeah, the final thing to do when you make regulations is the Office of Administrative Law has to review it and approve it. There's every expectation that they will.
That they will. Okay.
Yeah.
Because I was thinking that since this affects the business community, that Gavin Newsom might not sign it if it was up to him at this point in his career, since he's in hot water.
Yeah.
But that has nothing to do with it.
No, I'm sorry. He does have great hair and great teeth, though. You got to hand it to him. No matter what
there's a anonymous question or a comment on the line. It says, don't forget to mention that the changes also apply to PTP med legals.
Oh yeah. Well, that's interesting because there's a whole section in Sullivan on comp on this, where when is a PTP a med legal exam, right? And if it's like a final PNS exam, and arguably in some other instances where it deals substantively with med legal issues, it can be considered a med legal exam. And that there's case law that establishes that. So I think you're right. I think it would apply to those too. I like that. Yeah. So Megan, how are we dealing at the firm with retroactivity? I mean, all our cases set with exams set after April 1st.
Well, it's complicated as usual. The first piece is, we're not dreading a horrible, the first question is the doctor going to review the records? We think they'll probably review it. We'll issue a declaration, send it to applicant's attorney, see if there's any objection, try to get it through to the doctor. But again, this isn't finally approved. So I suspect that in some cases, the doctors will review the records, bill for their time like they used to. And if they do review the records, according to the reg, they can't bill you for it because you didn't do the declaration.
Right. But
I think that it'll probably be, sorry, go ahead.
Well, won't they, You say, okay, well, I can't bill you for it. Now I'm going to review the records and write the report properly with the declaration, so they can cure it.
I believe they can, yes.
Yeah. So we're going to go
Um,
through like the whole law firm and identify all the QME set after April 1st. There's actually 3 points on the workflow that need to change. Number one, you need to, when you write a letter to a QME, you need to identify which records you're going to send and right? So it's identifying. That means picking them out, right? So, I mean, look, we just used to just send all the records.
Yeah.
Probably shouldn't have been doing that, right? Because they're billing by the hour. But now our clients are going to be like, hey, we don't want to send them 6,000 pages of records. We want to send them 1, right? Just send the relevant stuff.
Yeah.
And so we have to review it before we do QME. That's a lot. That's a big deal. And then the next thing that's a big deal is declarations. So we got to go do this, and we have to send declarations on all the QMEs that are happening after April 1st. And then the third workflow change is that the defense has got to look at any advocacy letters with attachments for proposed records going to applicants' attorneys, and then see if we agree or disagree. And that could foment a lot of, fighting,
Yeah.
I think. So all these things I think need to be implemented now.
Yeah, and we are. So what we decided to do is create a list of all the QMEs, go through and where the records were substantial, talk to the clients directly about this proposed change and see what they wanted to do. Are we going to, if the records have already been sent, are we going to consider whether we're going to withdraw our, they've been sent to the applicant's attorney? Because remember, you have to send the records to the applicant's attorney 20 days before the initial exam so that they have an opportunity to object within 10 days, and 5 extra days on either side for mailing. And so in many cases, we usually send, 40, 30 days before the evaluation, even before an advocacy letter is sent, to make sure that the doctor has the records to review before the evaluation. So we have to go back and check for all those cases where we already sent records. How many records do we send? Another issue that's come up is we often...
Can we take it back? Can we say, hey, we actually changed our minds. We don't want to send all the records.
Well, I don't know. I mean, I'm sure it could be the subject of litigation, but I think what I would say is, yes, I have a case where there were like 8,000 pages of records, and a lot of them are irrelevant. So what I would propose to the applicant's attorney is to send him a designated list, try to negotiate it. But the reg also says that if there are disputes over what's going to the QME, that they go to the WCAB.
Well, I would think that because the declaration is required before the doctor can review the records, and that applies going forward, that we can say, well, there's no declaration for those records we already sent you. Therefore, they are not the records you are to review. Here is the declaration with the actual records to review.
Yeah.
Yeah, that's a great strategy. I like that.
That is.
I just came up with it right now.
Good.
And we've been inventing it as we go along this last week. I keep having insights I should have had before.
Yeah, it keeps happening to me too.
Yeah.
Speaking of, there's a question to me with regard to the California Hospital Committee and their discussions about the actual regulations. Yes, they wanted to know whether or not there was any discussion around what the QME actually, the doctor actually reviewing the records and not sending them to a third party. And that issue did come up, which is why we basically didn't want to do a per page evaluation or cost because of that. That he could throw it out to a third party, have them review it, and then just do a summary and include it in his reporting. So that's why we increased actually the base rate. We were willing to pay, $2,500 and, $5,000 for a complex AME as opposed to the per page. But that once it went through committee, it got shot down. So yes,
well, they're not supposed to do that.
They're not supposed to do that, and that's against their license. So that's how they kind of eliminated that discussion. The doctors in the group eliminated that discussion, saying that would be malpractice. So
how are you going to handle things with impropers?
Well, we did talk to our TPA, and we agreed that for propers, they're going to be the gatekeeper, and that they were going to do exactly what they always did, and that's go through the medicals and send what they want to send to the employee and have the employee review the relevant medical information, and they never answer anyway. They never object. Very rarely do employees object to what we're going to send unless it's non-medical information.
Okay.
I,
Well, sorry, Megan.
sorry, Mike.
Good.
I found it peculiar that they didn't put a cap on this. You know, we talked about the extreme example of cases where you have like 60,000 pages. And that could lead to a QME report. I think we did the math of $180,000. So it surprises me that there was no cap provided for the max that they could bill. There was a question in the comments that I wanted to address, Mike, and you and I had this discussion before this conference. The question is, does the multiplier apply to the record review as well, or just the base fee? And in our discussion, we concluded we don't think that it applies to the page based on the way that it's coded in the regulation itself. So we believe it's just the base fee. We think it's a pretty strong argument. Otherwise, certain provisions in there wouldn't make sense because they contradict each other.
Yeah, the way it's laid out, it seems, I mean, it's not perfectly clear, but it wouldn't make any sense to apply the multiplier to the $3. It doesn't say that.
Well, one of the examples we used is one of the multipliers is an interpreter, right?
Yeah.
You add 10% for an interpreter. But if the records are in English and the doctor's reviewing them outside of the exam, why would you have a multiplier on the page for an interpreter? It doesn't make any sense.
It doesn't make any sense, yeah.
Yeah, we thought about not even raising this issue in this call because I didn't want to confuse people, but it's good someone raised it. I mean, that argument probably will be made at some point, and but we just think it's defensible from the way we read it. So anyway, to sum up on the retroactivity aspect, I mean, we're going to have to, I think we have to look at all the QMEs that are out there right now, set after April 1st. And we have to look at what we send in terms of records and decide whether or not that's acceptable to us now and create declarations for all of them. But what is a record? What's a record? What counts as a record?
That's a good question. You know, we had a meeting with our administrative team to talk about some things that we thought were kind of fringe that could be knocked off of the regular PTP reports even. For example, a bill, you know, extra blank pages, or one of the things we talked about was the RFA. Now, this is not something that's been decided yet, but an RFA is a request for authorization that specifically goes in for the defendants to initiate UR. But the usual requests are actually in the medical report too. So to me, it's redundant, and I think it can be eliminated. But I'm sure there could be an argument made in the other direction that I haven't thought of yet.
Yeah.
Now, why would you have to send the RFA if you're sending the medical report? And generally in the medical report, they make the request.
Well, I don't think you would. That's
Okay.
my position.
Is that what you're saying? Okay.
Yeah.
One of the things that occurred to me is that when we're looking at records to send, we can't just do it like we do when we designate records for trial. Because when we designate records for trial, we just put in the stuff that helps us. Yeah. Right? We don't put in the stuff that helps the applicant's attorney. But no, if we're going to go through this process, when we decide to go through this process of culling the records and picking out the ones, we have to pick all things that are relevant, because otherwise we risk the report not being substantial. So it's a different process, designating records for trial and designating records for QME.
Yeah,
So
it's a bummer. We have to put in things that are against our interest if it pertains to the particular body part in order to make sure that we get a substantial medical report.
We were doing that anyways when we were sending all the medicals though, right?
Yes.
Okay.
But we weren't pointing it out in quite the same directed way.
Yeah, look at shining a spotlight on the record that hurts the case for the defense. Yeah, we don't do that.
So the declaration that you all have developed, are you providing that to your clients so that they can use it? Their TPAs can use that declaration when they are providing medical records to the doctor on improper employees?
I think we could. Mike, do you agree?
Yeah, you know, what we've created is a chart, a one-page chart, which shows the schedule of fees. And we're just finishing that. So we'll probably send that out under a Sullivan on comp alert to everybody. And now that I think about it, Megan, we also developed a series of letters that we can use inside our software standardized letters regarding different, like, we're not accepting these records from the applicant's attorney, we're not, whatever. But we're probably not going to send those out to the world. But I think the declaration is probably something we can send out. Megan?
Yeah, I agree. I think the declaration and the special chart. So we did a shorthand chart of base fees and add-ons and to try and help people calculate what to expect. And that was the purpose. One of the purposes of the legislation was to make it so that it's predictable. Unfortunately, sometimes it's predictable that you will get a gigantic bill. So we're just trying to roll with that now.
Right.
I think we have to err on the side of inclusion.
Yes.
Because otherwise we give, and I know I'm coming from a defense attorney perspective here, but otherwise we risk the applicant's attorney alleging that all the documents aren't in there, or we risk a charge that the report's not substantial. Now they'd have to connect the dots in order to support that argument,
Right.
but we don't want to give everyone an argument for withholding a record to save $3, right?
Yeah.
So I think that's probably the approach we have to take.
Would you be able to send, like, would I be able to ask my attorney to send the applicant attorney the relevant records, and then records that they considered not relevant, that they didn't want, that don't need to go to the doctor, so that the applicant attorney could review both and understand that we're not withholding anything, and then that would kind of take the argument away from them that the medical report was not substantial?
So our practice that we're developing internally is that we're going to send, most likely, first of all, we already order subpoenaed records and a copy goes to applicants counsel. So they should have the complete subpoenaed records themselves.
Okay.
And the way that we're going to prepare our exhibit list is with page numbers. So we're saying designated records of Kaiser Permanente Vallejo, and then we'll put pages 5 through 25 and list all the ranges that we're going to send.
I was wondering how we're going to do that. Are we going to do, because I was thinking, well, we could just send the records, even though it's duplicative of what they already have, because we have to copy them for the QME anyway.
Right. So it becomes a logistical problem with time, because you have to remember that if we're designating records, this puts a new time burden on the attorneys and their cases. So they need some time ahead of that to designate records, and the legal assistants to synthesize and pull all those records, which are currently all electronic, into one PDF takes some time too. So we decided that in order to maximize efficiency, we would probably just say, you've already got the records, here are the pages we're going to use, to the applicant's attorney. And that gives the assistant the time between when we send it to applicant's attorney and when we send it to the doctor to prepare that smaller packet for the doctor. It was more just logistics in that thinking. And a lot of the planning we're doing right now is, we're just going to try a bunch of things out and see what works best. We don't know what it's all going to lead to in response to this. So this is our best position that
What
we've
do you
come
think
up
of
with.
Angela's idea that if we say, here's the records that are relevant, here's the ones that aren't, and we send them to the applicant's attorney, that may make them, do their job for them a little bit so that they don't give us such a hard time.
Well, they're getting the ones that aren't relevant when they get the complete packet.
Yeah, but they got to pick through. You know what I mean? If you just identify the pages.
Have you just already collated the ones that you want to send to the doctor and give them the other stuff that's not relevant? Then they thumb through it, and maybe they might find a report that they think is relevant or not, and they can add it to the stack that you're going to send to the doctor. I don't know. I mean, if you just send them a big stack, then it's less likely that they'll review it and say, no, I want to send it all. I would,
be costly though.
in my opinion.
It's going to be
I think
costly.
you're gonna-
It's gonna take us more time.
Yeah, you're going to end up with
Okay.
a lot of administrative costs and time there that are probably not going to work well for the
On your side, from my attorneys?
Yeah, I mean, I think this is already going to put, what we've decided to do as a firm is we used to have certain alarms and diaries for when you write your advocacy letter. So you want to write your advocacy letter closer in time to when the QME is going to do its evaluation. You have more information, you have more records, you have more medicals, but you want to give it enough time so you can provide it to applicant's attorney. And now you also have to give a cushion for designating these records. So there's kind of, I think, going to be 2 time periods in terms of administration. Right now, what we're going to do is we all have open cases with subpoenaed records already that we've reviewed and we haven't designated. So there's going to be a period of time where we have to go back each time there's a QME and designate records for those cases. But as new records come in, I think our attorneys are just going to start designating them when they review them the first time. So I think we're kind of going to see two phases. In the initial phase, it's going to put a lot of additional time on those attorneys, in my
That's
opinion.
funny how that shakes out, because right now we get records in, we review them, but sometimes you get them in at the same time you're setting the QME. So sometimes you're reviewing the records at the same time you're preparing the QME letter, and sometimes you're not. So, often there will be 2 reviews, and sometimes there'll just be 1, which takes a little longer.
Yeah.
But when we get into the calculus as to when it's cost effective to do this, that could really matter. Hey, what do you think about this? Applicants' attorneys have no incentive to do anything but send all the records, right? I mean, they don't have to pay for this.
Exactly.
So they're going to say, I can see some applicants' attorneys and maybe some judges agreeing with this statement. We just have to send all the records, otherwise the report may not be substantial. We're not doctors. We can't discern what's relevant and what's not relevant. So the only legal solution is to send all the records. And all this designations of records by defense attorneys to try to save a few bucks is not legal. How do you like that argument?
Less money for you, more money I spend on medical reports, less money for you, applicant attorney. How about that?
Well, I think,
I mean, there is no, employers don't have an endless stream of cash. I mean, honestly, you want to spend it on reviewing 12,000 medical pages of medical, or you want to, possibly get some kind of settlement, because obviously we can't do both.
But that may be exactly what the applicant's attorney is trying to engineer, right?
Mhm.
He's by increasing the threat of cost. Then they turn around and say, well,
Yeah.
how about you pay me an extra few grand on the case?
Yeah. And how about you? I mean, we do that all the time. There's a lot of horse trading going on, because of continued discovery anyways. So if that's the issue, but here's the thing. I mean, is this process and regulation cost prohibitive, or to some employers to the point to where it's impeding their ability for discovery? I mean, honestly, if there are, voluminous medical records and a complex case, will some employers choose to settle as opposed to move forward and do any medical legal evaluations at all? And that's going to be a cost benefit analysis that employers and TPAs and carriers are going to have to make,
But this is working for the applicant's attorneys.
Yeah.
well, this is actually something we discussed too, is that right now, especially in Northern California, we see that there's a QME race, right? And if you and it starts the instant it's represented.
Right.
So if you lose that QME race, you're going to end up with a report that's double, maybe triple the PD that you would have seen otherwise. So while I like the idea of, settling on a PTP report, and I certainly could settle early with or without an MMI report, I think we're going to see that we're still going to want to get the QME, because if we don't, the exposure goes up substantially for the employer, at least up here. I mean, the race is real.
At least you want to set the QME, right?
Yes.
And then it's settlement talk time. But that's always been the way it is. It's just with this added frictional cost, applicants' attorneys may perceive an ability to increase the overall nuisance value of settling cases. Cost of suit is higher.
There was a question from one of the attendees, and they're asking, how would you determine what's relevant? What's a relevant record to send, and what's not?
That's
as an
that's a
attorney.
great question. Now, I have a number of clients that insist, in order to save costs, on paralegals reviewing medical records.
So, but I think your point is, Mike,
Is that a good idea?
Well,
well,
I like all ideas right now.
This is a really important thought too, because it seems like the trend in the DWC has been to take medical decisions out of the hands of lawyers and judges and put them in the hands of doctors. That was the whole premise behind a UR-IMR dispute resolution, right? But if we're in the position where we're talking about what's relevant, now what's going to happen is, in a case with a lot of records, the defense attorney is going to want to designate. The applicant's attorney may dispute it. You go to court, the judge may say, we're not doctors, so then we're going to appeal it. But we're the ones doing it. We're the ones saying, well, it's a back, so it has to do with back. or it's a back and he's a smoker. So that has to do with the back. And we're going to have those fights in court.
Well, let me take the position that the argument that all records in every case need to be sent to the doctors is wrong. And if applicants' attorneys try to enforce that and judges start to agree with it, but we're going to have that fight. I anticipate seeing that argument. I anticipate a lot of litigation over it.
Mhm.
A lot of expedited hearings. So the applicants, you have to send everything. Now give me more money on my settlement. I would say, no, you don't have to send everything. I mean, we can designate pages. No, you're not a doctor, right? And go to the judge. Judge doesn't want to, I mean, judge is looking, I have to review all the records and determine what's relevant and what's not. No, I'm not doing that. Just send all the records. And we're gonna say, no, judge, that's not how we're gonna do it systemically. Otherwise, we're gonna pay $180,000 for all of our doctor's reports. And it's not necessary. Not everything is relevant. Duplicates.
And that again, if Megan is saying that all regulations were the intent of all the regulations was to take the WCAB out of making medical decisions, I mean, in a way, we're throwing it back to them to tell us what's relevant in a medical file, and they're not going to want to do that anyways.
Well, applicants, attorneys, and Megan, you were saying this. Well, I mean, judges, if I was a judge, I'd be pushing it back on the applicant's counsel.
Applicant's attorney.
Yeah, applicant's attorney needs to say, okay, this is what I would say. I'd say, Your Honor, I'm all ears. If applicant's attorney says that I forgot something that was relevant, let's put it in there if it is. But I expect the applicant's attorney to do his job and tell me what I missed.
Right.
Yeah. And then that, of course, puts it back on them. So now maybe the frictional cost is on them too. Do they have time to review all their records for relevance before every QME?
Yeah.
They do not. So when they come to us and say, we're going to increase your cost, we'll say, okay, let's do that. Let's increase your cost too.
Which is why our position is, early on out the gate to pick those battles. When is it right to take that fight, to a hearing, and maybe get out in front of this and let the applicant attorney firms that we deal with understand that we're not going to let them get away with that. We're going to take them to task on that.
Okay, now this leads me into a topic that came up a couple of nights ago, and we really worked it hard. And the question is this: is there some instances where it's going to cost you more for the defense attorneys to designate records than it is for the doctor to review them? And you know what we did? We did a whole bunch of math. I want to tell you about it. Okay. You guys mind?
Oh, please.
Okay, good. All right. So let's assume a bunch of things which are totally wrong in almost all cases for purposes of figuring this out. Ready?
Okay.
All right. So we're going to assume it takes an hour for an attorney to review 100 pages. Let's assume attorneys are charging $170 an hour, a woefully, sadly low figure for attorneys.
Right, Angela?
Right? Yeah.
On the record. We should probably disclose that we have a lot of Kaiser cases we defend.
Yeah.
Yeah. And then let's say that when an attorney reviews records and culls them, it's reduced by 80%. And we made that up number 2 because it's not right. And almost all, I mean, every case is going to be different for all 3 assumptions, but I needed to make some in order to do some math. Now let's say there's 1,000 pages of records to review, and the attorney reviews 1 hour for every 100, which means $1,700 is the cost of the attorney's review, right? And then the attorney picks out 20% of the records, which is only 200. So the doctor doesn't have to review any records. And that's the cost of the attorney reviewing the records. It's $1,700. There's no doctor review add-on area. Now, if the records are sent to the doctor, then they review 800 pages at $3 a page. It's $2,400. So there is value. If there's 1,000 cases and all the 1,000 pages and all the assumptions are true. And what we found is when we looked at it is the more the pages, the more value there is in the defense attorney reviewing the records. And the reason for that is because for every 100 pages, the attorney is charging $170, but the doctor is charging $300.
Yeah.
So another example is there's 5,000 pages. The attorney bill ends up being $8,500, sends the 800 pages of records, sends the doctor the pages to review, and you add that up and it comes up to $10,900. But if the doctor reviews all 5,000 pages, the cost is $15,000. So what we did is we kept going lower and lower and lower and seeing where the threshold was. And the answer seems to be, using the assumptions we have, is 450 pages. So we said, okay, so if there's less than 450 pages, the attorney should not take the time to review because there's really no savings there.
Right.
And if there's more than 450 pages, the attorney should take the time to, but then I'm going to change my mind. Okay. And change my mind. Because the first thing I'm going to say is that the assumption that the attorney is going to take 100 an hour per 100 pages is a big one. Because like I said, they've usually, a lot of times they've already reviewed the records. And anyway, they'd be billing you for it anyway, right?
Right.
The real question is how much time are they spending on 100 pages of records independent of initial review? That might be a lot less. But on the other hand, if they haven't marked the pages, like our software allows us to mark pages, highlight, make notes. If attorneys don't have that software, it's, it may be a lot less. It may be half as much time. I mean, you got to refamiliarize yourself with the file. If you did half as much time, then we figured out the threshold goes down to about 275 pages, not 450. So if it's under 275, you don't review. Over 275, you do, because you assume that you're already paying for the review anyway.
Yeah.
But then there's another big assumption, which is that the attorney is going to reduce the records by 80%. And we think if that's true because when you designated records for child, they're really small. But on the other hand, we're going to do more records. And you got to think like medical reports, deposition transcripts, can't really reduce that. Right. So what if it was 40%? Well, if you went back to the hour for 100 pages, and the threshold number ended up being about 550 instead of 450. So maybe these two things cancel each other out.
Yeah.
And maybe we should go with 450. But then you got to ask yourself, what's happening when the applicant's attorney starts making legal arguments, right? We have to review, if we're not sending all the records, we have to review their submission, maybe.
Right.
And if we start fighting about it, how much does an expedited hearing cost, Angela?
About
What's the attorney bill look like?
$1,000, $1,200.
$1,000, right? But then there's also the back and forth before and after.
Right. And that's
Right.
going to be in there too. Yeah.
Maybe
Plus the appeal.
Plus
What
the appeal.
percentage of cases is that going to happen in? Probably higher on the front end than in 6 months when we figure this stuff out.
Right. That's
So
that's the cost of doing business. So
yeah, it's a value decision. I made a recommendation to you guys at Kaiser that if it's 1,000 pages or under, we just send all the records.
Yeah.
Pick
We're
our
doing the
fights.
same.
There are plenty of fights.
Mike, we're making the same determinations on the non-litigated side with our TPA. We are making the same. When is it that we're going to just send, what is the sweet spot? Are we going to just send all the records and later are we going to do some kind of review of what's relevant? How many records is that? And we're doing the same thing. So there's going to have to be a gatekeeper on both sides. Somebody's going to have to make sure that the glut of report records don't go to the doctor so that they'll charge us for all that. Now, one of the questioners asked, what if the applicant attorney sends medical records and the defense attorney sends medical records? Will the doctor charge to review both stacks?
Well, here's the thing. I mean, I said there's 3 workflow practices we have to change, right? One is inspecting our own records we send. Another is filing a declaration. And the third is a scrutiny of the records the applicant's attorney sends. Because they'll try and send all the records, or if they send some, we need to compare and see what's duplicative and file appropriate objections.
Mm-hmm.
And that's another advantage of just sending all the records.
Yeah.
Right? So that's why I raised it from 450 to 1,000, because these costs and attorney's fees are going to add up rapidly. Plus, we're going to be in plenty of fights. We're going to have plenty of fights to set the table for how this is actually going to work over time. But hey, I want to ask you, Angela, what's the number you guys are picking at Kaiser?
I think we're 800 to 1,000.
Yeah. So Megan and I sent every team lead in the whole firm said, get in communication with the clients, lay this all out, pick a number, pick the process, pick what they want, because this is a minefield.
Yeah.
If we don't object and the client would want us to, and there's a huge bill, we're dead, right? But if we do object and we spend a huge attorney's bill, the client's not gonna be happy with that either. I don't even know what's gonna happen with the billing software programs. Are there entries for this? Are you guys gonna be?
Yeah. Are there?
I don't know. Or are you guys going to be objecting to reject, or your billing software going to say, no, we can't get paid because we don't recognize this activity?
Yeah. Well, I mean, it would just be under medical report review. It's the same, right?
Yeah, but if you bill to re-review records, that's often cut from a bill.
Yeah.
So you gotta, we'll have to work that out with the
We'll have to work
various
that out
billing.
with the billing
Yeah,
folks. with
now I'm thinking maybe
Covant.
we gotta talk to Janie about some macros.
Yep.
Yeah, pretty crazy, huh? 800 to
Yeah.
1,000.
Well, and so right now what we're doing is we're doing a cost benefit analysis and sending it to the adjuster at the onset of something that looks suspicious,
That's good.
and letting them tell us what they want us to do. Because until we have the guidance from our clients on a sort of administrative client-wide level, we need to make sure that our clients aren't surprised.
Yeah.
Just another day.
We're gonna go client by client.
Yeah.
Yeah, and then I think maybe in a few months, 6 months or so, we go back to those 3 assumptions I talked about. How much attorney time is really being billed, right?
Oh, you can re-review it and see what,
Yeah,
if we need to change those standards.
right.
Yeah.
We can learn,
Mhm.
we can learn like what's actually happening. I don't know what percentage of the cases have 1,000 pages or less, but it's got to be a lot.
Yeah.
Well, I had 4 QMEs come up that had already been sent, and there was only one that caused me concern.
Yeah.
I mean, that's a very small case study for you.
Yeah.
We have people
Well-
on the call indicating that QMEs that are set after April 1, they're already asking for declarations, because it sounds like they don't want to be in the position of getting all these records and reviewing them and not getting paid either. They want everything to be known up front so that there's no surprises.
Well, that's
We're
why
seeing-
we said that you got to pull all the files with QMEs coming up and do declarations if they're coming up after April 1st.
We got tipped off to this actually just a few weeks ago, because one of the QMEs requested fees in accordance with the new schedule for their depot. So we started really investigating what was going on.
That is going to be interesting. I wonder if these fees as established will be seen as, the reflection of actual value legally for exams and things that happen before April 1st. Now, remember, sorry, go ahead.
I wonder if the regulations will do as intended and get more qualified specialists to become QMEs, because financially now they can do it, as opposed to how the regulations were before.
I do too. I really wonder about that. I know CA was raising a lot of stink, saying, "Hey, this is not enough." They're saying, "Look, we used to get paid this much anyway, billing by the hour." And so where's the increase in fees? How are we supposed to attract more doctors?
Yeah. I don't know. I've never received a $160,000 bill for somebody reviewing a stack of subpoena medical records. I think the highest we went was like 10 boxes, and they were going to charge us $100,000 to review them.
Yeah, you know what? We should have been reviewing them and redacting them all along, probably.
Yeah.
Right. I mean, just nobody.
Which maybe that's why they fought for a per page, because if they were sending them offshore, secretly, then it didn't cost them anything, but now it will.
I mean, one of the questions in the comments that I think is good for this is, can a doctor request additional records? And I think the answer is clearly yes. They do now. They can say, I need additional stuff to make my decision. I need to know one of the things that happens that you get in the Kaiser records is there's a list at the beginning with all their conditions, when they were diagnosed, all their medications, stuff like that. Would you want to include the history there so that the doctor can decide, hey, I need more about this condition in order to make my conclusions? Or I think that we're going to see that.
Well, you have to think though that we're representing that we're sending everything relevant. So there shouldn't be any. The doctor saying, "I want to see more records." I mean, we sent them everything, right? Unless
if something is referenced in a medical report and they want you to go dig for something else,
or they can request that we subpoena new records.
Yeah, that could happen.
Yeah, that's true. You can do that.
I'm imagining like someone with carpal tunnel, and we don't send all the records about someone's weight over the years, and obesity can be a factor in carpal tunnel. So maybe the doctor wants to see more records about the weight in order to draw conclusions about apportionment. let's say, or the smoking thing. If someone's not healing well, they want to see what the medical history is with regard to their smoking in their back. So I'm kind of thinking of it in terms of outside the box. Yes, we provided everything that said back, but maybe the doctor needs something else because of some reference to something else that they see.
Fair enough. Well, we're just about out of time, my friends. Is there any other questions or comments you see? Because I've been looking at them that you think might be of use before we sign.
Let's see. I've been looking at them, but they're coming in fast and furious, people.
85 questions.
Yeah. Well, folks, look, if you need to know something, if you have a question, you got the Sullivan on Comp email. If you don't, it's right on the website. And after these webinars, we typically get a lot of questions, and we're happy to sort through them, give you answers, give you our thoughts, call us, contact us. I mean, we're an educator, so we're happy to continue the dialogue. I'm certain that there's a whole lot of stuff that we haven't thought of yet.
Yeah.
And that we're going to encounter, and that a month from now, our vision on this, may need another webinar.
Yeah. This is going to be progressive.
Yeah. Well, I remember with COVID, my first COVID webinar, I thought, well, there won't be many workers' comp claims with COVID. Yeah. And I actually said that to 2,000 people in front of the whole world, permanently damaging my reputation in the industry.
Nothing like boldly stepping out, Mike.
Yeah. I mean, you got to realize that you have to learn as you go to some extent, but we're going to think of everything we can. We thought of everything we can. So
and we appreciate all your questions too, because it really helps us keep considering what we might have missed and having more insights. So please do forward them, because if we haven't thought of it yet, we want to make sure we cover it.
Agreed. Okay. Well, let me say thanks, Angela.
You're welcome.
And thank you, Megan. On behalf
Thanks, Mike.
of you, I'm Mike Sullivan, and we'll sign off until the next time.
Bye, everybody.